Hi everybody, this is Rob Darrow from INACOL. We're glad you're here for our leadership webinar today entitled Protecting Student Privacy in Blended and Online Learning, the new FERPA guidance from the U.S. Department of Education. We've got an exciting lineup of speakers to share this information with us. A couple quick housekeeping tasks. Number one, if you're called in, please make sure that your phone is on mute because it reduces the sound. And then secondly, if you are in our regular Blackboard Collaborate room, there's nothing else you need to do. Just listen in and type in questions in the chat room. So with that, welcome, and I'm happy to turn this over to Maria Worthen, our Vice President for Federal and State Policy.
Thank you, Rob, and good afternoon, everyone. Thank you for coming to attend this webinar on what is a really important emerging topic in our field of blended and online learning. I'm really pleased to have a very stellar lineup today with a lot of information to get through in the next hour. So I'll be moderating this conversation, and the bulk of the presentation is going to be from the Privacy Technical Assistance Center staff from the U.S. Department of Education. So on the line, we have Frank Miller, Management and Program Analyst with the U.S. Department of Education, and Ross Lemke, Technical Assistance Manager for the Privacy Technical Assistance Center at the U.S. Department of Education. And at the end of their presentation, Themy Sparangis, who is the Chief Technology Director for the Los Angeles Unified School District, is going to provide a district-level perspective on federal and also state privacy concerns. So with that, let's get started. Just a couple announcements before we do. I want to alert everyone, in case you are not already aware, that the INACOL Blended and Online Learning Symposium this year is going to be taking place in Palm Springs, California, November 4th through 7th. The theme this year is Powering Personalized Learning, and registration will be announced soon. This is a fantastic opportunity to connect with colleagues from all over the field in many different roles in the field of blended online and competency-based learning. We expect to have over 2,200 experts, educators, and thought leaders from the field. So keep an eye out for that. And this webinar, we will be taking questions. You'll see on the left-hand side of your screen, there's a chat box. Keep in mind that if you do send a message to the moderators, all the moderators will see it, as well as if you send a message from one participant to the other, moderators will see that. If you put it in the main room chat box, that's where you can submit a question or a comment. We're really grateful to have the U.S. Department of Education here today, but we also understand that they won't be able to answer every single question that is posed today. So they'll do their best to answer the questions, and for the questions that they can't answer, we'll try to follow up. And after this webinar is over, a link for those of you who are members will be accessible through the INACOL member forum to an archived version of this webinar. So I just want to start by framing this discussion in terms of INACOL's mission, strategic priorities, and policy priorities. So for those of you who are not familiar with INACOL, our mission is to ensure that all students have access to a world-class education and quality blended and online learning opportunities that prepare them for a lifetime of success. We have 3 strategic priorities, which is the development of new learning models, quality assurance for blended and online learning, and policy and advocacy. And although today's topic is about a federal issue, I think that as many of you have seen, the issue of student data privacy has really exploded this year in the states. According to the Data Quality Campaign, they are tracking about 80 bills in over 30 states across the country just in this session. We're in an era of WikiLeaks and the NSA and the Target hack, and people are starting to wonder about the role of technology and their privacy and safety of data. And when it comes to their own children, they want to be assured that those data are safe. So I just want to quickly go over our state policy priority issues, because where FERPA stops, the state role comes in. So our main policy priority areas are creating competency-based education systems, improving equity and access for students to blended and online learning opportunities, ramping up quality assurance for online learning, providing room for innovation, and then finally, which is relevant today, is supporting new learning models through connectivity, data systems, and security. And so under that priority area, where we've got broadband telecommunications infrastructure, data systems, and the secure and ethical use of student data. Why is this issue so important for our field? Well, blended and online learning powers the ability to personalize instruction and really transform our education system. But without data, we cannot personalize instruction at scale. But on the other hand, without sensible data governance, we cannot sustain new learning models that are powered by blended and online learning. So as a field, we really need to get this right. And I'm very pleased that the U.S. Department of Education recently came up with guidance that's updated for the digital age. FERPA, as Ross and Frank will tell you, was passed many years ago during a different time. And so I just want to applaud the Secretary and the staff of the department for their leadership in trying to provide guidance for the field on this important issue. So with that, I'm going to turn this over to Frank and Ross.
Well, okay, I can see that there's a little jumping bar on my screen that you guys can hear me, so I'm just going to keep going. Welcome to our webinar entitled Protecting Student Privacy While Using Online Educational Services. My name is Ross Thumke, and I'm a Technical Assistance Manager at the Privacy Technical Assistance Center, otherwise known as PTAC. With me is Frank Miller, the team lead for the Family Policy Compliance Office at the U.S. Department of Education.
Good afternoon. For those of you out on the West Coast, I guess it's still good morning. My apologies, as I could not upload a stock photo, so I will be, those that have video access, the faceless voice that you're hearing from DC.
So if you have questions during the webinar, please type them in the lower right-hand corner of the, actually in this case, lower left-hand corner of the window. At the conclusion of the webinar, we will, one of the moderators will feed them to us, and we'll try and answer some select questions. We may not be able to answer all of your questions. We might not be able to answer any of your questions, either due to time constraints or simply because we don't know the answer at this time, or because it depends, or because we want the lawyers to go weigh in on it as well. But we will, at the end of the presentation, be giving you our contact information. So if you have questions that we don't address during the presentation, feel free to submit it to our Technical Assistance Center. We will get right on getting you a better answer than it depends. Although with FERPA, in a lot of cases, the answer is it depends. So speaking of FERPA, we have our first poll here. So we'd like to just get a general idea of the familiarity with FERPA from those of you in the audience. So if you go and those of you familiar with Blackboard, you'll see a little A icon right next to where it says your name. I see people already chiming in right now. We're just trying to get an idea of what sector you guys represent. So I'll let that go for a few seconds, and then we'll carry right along. Okay, well, not to have too much dead air here, I am seeing a overwhelming percentage of you are in K-12 administration, with some K-12 faculty sprinkled through, and then, of course, the nebulous category of other. So moving right along, The ever-changing landscape of technology is difficult to keep up with at best. PTAC and the department recognize that there is a need for more guidance around protecting student privacy in an electronic age. Remember that FERPA was enacted well before the preponderance of electronic data files and student information systems. As such, FERPA is very unclear around the protection of electronic student records. Today, we are going to discuss, at a high level, guidance to help schools and districts and service providers navigate the best practice considerations for protecting student privacy. Remember that there are legal protections for student information used online, and you should also consider state, local, and tribal law protections of student information as well. Finally, it is important to think beyond simply being compliant with FERPA. We always recommend employing best practices in addition to compliance requirements such as PPRA and FERPA.
We must provide our schools, teachers, and students cutting-edge learning tools, and we must protect our children's privacy. We can and must accomplish both goals. This is a quote of the U.S. Secretary of Education, Arne Duncan, back on February 24th when we released this most recent guidance document.
Technology is everywhere in the education community. There are some examples of technology in schools that may contain or use student personally identifiable information, or PII. Student information systems such as Pearson or eScholar, productivity applications such as Google Apps or for Education or Microsoft 365, educational applications such as teacher dashboards and fundamental school services such as school transportation services or cafeteria services. This particular guidance relates to the following subsets of education services such as computer software, mobile applications, web-based tools that are provided by a third party, accessed via the internet by students and or parents, and are used as a part of a school activity. This guidance is not covering online services or social media used in a personal capacity or those that are used by the district in administrative function that are not accessed by parents or students.
With the changes in the computing and telecommunications sectors over the last couple of decades, we've seen corresponding shifts in these technologies' use in the education sector. This has led to a number of new privacy and data governance challenges that schools and districts have had to address. For starters, the growing complexity of many of these technologies, coupled with budgetary constraints, has led many schools and districts to contract out a greater share of school functions rather than performing them in-house. As more services move online and as technology advances, we have many new types of data that are being collected, and a whole lot more of it overall. Many online services also increasingly use a take-it-or-leave-it terms of service agreement, often called a click-wrap agreement, instead of the two-party written contract model used in more traditional contracting relationships, which raises new challenges that we'll talk about later in the presentation. Faced with all these developments, our major challenge is to find a way to leverage the tremendous potential of these new technologies and data in an effective and appropriate way without compromising students' privacy. So to that end, what role does the U.S. Department of Education play in protecting student privacy? Most importantly, we administer and enforce a number of federal laws governing the privacy of student information, including two laws that we'll be talking about today in the context of using online educational services, the Family Educational Rights and Privacy Act, or FERPA, and the Protection of Pupil Rights Amendment, or PPRA. But administering and enforcing these laws is not all that we do to protect student privacy, though it does keep us in the Family Policy Compliance Office quite busy. We also work to raise awareness throughout the education community of the privacy risks and challenges involved in collecting and using student data. We provide both general and targeted technical assistance through PTAC on privacy and security issues to schools, districts, and states. We are active in promoting a number of privacy and security best practices that we encourage education stakeholders to adopt.
Now I'd like to gauge your level of expertise with FERPA. So please, using the polling tools, please rate your familiarity. FERPA, what's that? You know enough to be dangerous. Or you could, we could add you to our national cadre of experts on FERPA. If that's the case, go ahead and ship me your resume.
And just as a reminder, the place to select your option is right under your name in the participant box. You'll see a little button that has the letter A on it, and that will generate a drop-down.
Okay, well, we got a number of responses here. Most of you know enough to be dangerous, and there's one of you that should be added to our national cadre of experts. So moving right along.
Put simply, FERPA guarantees parents access to the information contained in their child's educational records and protects those records from unauthorized disclosure without the parent's consent. More specifically, FERPA gives parents the right to access and seek to amend their children's education records. The law protects any personally identifiable information, or PII, from those education records from unauthorized disclosure, and it requires written consent from the parent before sharing PII with third parties unless an exception applies. There are a number of these exceptions to FERPA's written consent requirement, and those of you who have sat through any of our prior webinars are undoubtedly familiar with some of them. For today's discussion, we're going to focus exclusively on two of these exceptions, the directory information exception and the school official exception. But as I said, there are a number of other exceptions to this consent requirement, and we'll have a link to the PTEC website at the end of the presentation if you want to find out more information about any of them. So Ross, can you tell us about these two exceptions to FERPA's consent requirement?
We know students don't attend school anonymously. Therefore, FERPA allows schools to release certain information without consent. Some examples include name, address, email address, photographs, degrees, and awards receipts, such as valedictorian. Keep in mind that much of this information could be PII, and just because you can do it doesn't necessarily mean it's the best practice. In addition, remember that schools must provide the list of what they consider directory information in its annual notification to parents, and that parents can opt out of that information being shared. Some common uses of this exception are yearbooks, student directories, and concert programs. Again, remember that parents have a right to opt out of this. The school official exception is generally the exception that allows those involved in the education of students to be able to deliver education services needed to the student. When involving a third-party provider, or TPP, it's important that the following caveats are met. It has to be a service or function that the school or district would otherwise use its own employees. For example, this could be student information system services or dashboards that are provided by a vendor. The use of the data by that TPP is under the direct control of that provider with regard to the use/maintenance of those education records. The use of the data aligns with the annual notifications sent to parents on what constitutes a school official with a legitimate education interest. The data is not used for unauthorized purposes.
As we mentioned before, FERPA isn't the only federal law that protects students' privacy. There's also the PPRA. So let's do another little poll, and I ask that you be honest. How many of you have ever heard of the PPRA before today? And for those of you who have, how many of you understand how it applies to the students' use of online services? I'll wait a couple minutes while you answer those questions. Okay, I'm glad to see we have a fair number that are in with the Pen Pal Research Association. But honestly, you're all in good company. Awareness of the PPRA lags far behind that of FERPA, though we hope to change that moving forward. Though the PPRA has been around for many years, its most notable changes, for the purposes of today's discussion, were introduced with it when it was amended as part of the No Child Left Behind Act of 2001. While the law is mostly known for its provisions dealing with surveys in elementary and secondary schools, the so-called sex, drugs, and rock and roll provisions, it also includes limitations on the use of personal information collected from students for marketing purposes. Subject to certain exceptions, including one notable one for education products and services, the PPRA also has requirements on parental notification and provides parents the opportunity to opt their children out of these activities.
So Frank, is student information used in online educational services protected by FERPA?
As much as I wish I could give a definitive answer to that question, and as much as I appreciate those on Twitter who recently poked fun at us for saying in the guidance document, the real answer to that question is, it depends. Some data used in online educational services is absolutely protected by FERPA. Say, for instance, the student profile information, like name, grade, and email address, that a school enters into an online system to create students' user accounts. When that information is taken from education records, like the school student information system, then FERPA would absolutely be implicated. But there are many different types of online services, and even more types of data, much of which probably isn't protected by FERPA. Take, for instance, an online portal that students use to watch tutorials or complete interactive exercises without logging in or using individual accounts. In these cases, no PII is involved, so FERPA would not apply. In the end, schools and districts will typically need to evaluate the use of online educational services on a case-by-case basis to determine if FERPA-protected information is implicated.
What does FERPA require if PII from student education records is disclosed to a provider?
Well, the most straightforward approach would be to have the parents provide written consent for their children's information to be disclosed to the service provider. But, as anyone who has ever tried to collect field trip permission slips can attest, this is often not an efficient process, and may be unworkable for essential services central to the education process. Without written parental consent, disclosure of PII from education records can only occur under one of FERPA's exceptions to the consent requirement. In the case of online educational services, this will most likely be done under one of the two exceptions we discussed earlier. The directory information exception is an easy way to disclose student information to create student accounts, but only if all of the data elements that will be disclosed are properly designated as directory information in the school or district's annual notice. Also, using the directory information exception may be problematic in those cases where parents have elected to opt out of directory information. It is often unfeasible for a school to maintain two separate systems for the same function, an online one for the majority of students, and a separate paper-based one for those students whose parents have opted out of directory information. Because of the complexities of using the directory information exception, either because of the data elements involved or because of the parental opt-out option, FERPA's school official exception to consent is often the best, or at least the most efficient, option to disclose information to third-party service providers. As we mentioned before, however, when using the school official exception, there are a number of requirements that must be met. First, the provider must meet the school or district's specified criteria for school official with legitimate education interest, as documented in their annual FERPA notice. The provider's use of the PII must be for our authorized purposes only and under the direct control of the school or district. And in those cases where the third-party provider will be creating or maintaining education records for the school or district must ensure that the parents retain the right to access those records, either directly from the provider or more likely from the school or district who obtains them from the provider.
So Frank, under FERPA and PPRA, are providers limited in what they can do with the student information they collect or receive?
Again, I'll have to say it depends. In this case, it depends on how the information was collected or disclosed. If the PII was disclosed under the directory information exception, then typically there would be no other limitations on using the data for other purposes. If the information was disclosed under the school official exception, on the other hand, then the PII may only be used for the specific purpose for which it was disclosed. Third-party providers are prohibited from selling or sharing the PII or using it for any other purpose except as directed by the school or district and as permitted by FERPA. But whether or not FERPA-protected information is implicated, whenever personal information is collected from a student, the PPRA may also apply. So the PPRA's restrictions on marketing may apply even where there are no other legal protections on the data. We want to stress, though, that FERPA and the PPRA represent minimum legal requirements. They are the floor, not the ceiling, when it comes to protecting students' privacy. Schools and districts can and often should consider placing additional limitations on what online service providers can do with student information by inserting those provisions into their agreements with the service providers.
What about metadata? Are there restrictions on what providers can do with metadata around students' interactions with their services?
I hear the word metadata thrown around quite a bit. What is it? And are there restrictions on what providers can do with metadata about students' interactions with their services? Metadata has been used a lot in the news recently, and many of those who use the term have not done a very good job explaining what it actually means. Put simply, metadata are pieces of information that provide meaning and context to other data being collected or used. For example, if we were interested in tracking a student's performance on a particular online activity, or as more often the case, trying to find patterns in how a large number of students perform on a specific activity, we would want to know how the students did on the activity, the data, but that performance information would have a whole lot more meaning and analytical use if you also knew the date and time the student performed the activity, the number of attempts they made, how long their mouse hovered over the answer button, which is an indicator of indecision, or whether they changed their answer before submitting it. All of these other pieces of contextual information, collectively known as metadata, are tremendously useful for education technology developers in building and enhancing the underlying algorithms used in personalized learning and other similar technologies. Metadata that have been stripped of all of their direct identifiers and other indirect identifying information are not protected under FERPA, because at that point they are no longer considered to be PII. I'll make the important caveat, however, that when you're looking to de-identify metadata, it is important to consider that, depending on the context, school name or other geographic information can be indirect identifiers in the student's data. People often forget that point. Assuming it's done properly, de-identified metadata can be used by providers for any number of other purposes, unless prohibited by other laws or by more restrictive data use provisions in the provider's agreement with the school or district.
There are other laws to consider, such as COPPA, which applies to commercial websites and online services directed to children under age 13. This law is administered by the Federal Trade Commission, so please see the link that we have above for more information there. Now we will walk you through several best practices on protecting student privacy. The first, which we just discussed, is that it's critical to be aware of other relevant laws such as COPPA that may apply. You should also be aware of your local, state, or tribal laws. In fact, many states and local entities have pending or passed laws regarding the protection of student personally identifiable information.
Administrators will also want to be aware of which online educational services are currently in use in your school or district. The first step in protecting student data is knowing what information is being collected or shared, by whom, and for what purpose. And you can't even begin to answer these questions until you know what services are being used across your own organization.
It is important that your organization has policies and procedures consistent with state, local, and federal law to evaluate and approve proposed education services. For instance, you may have a policy that requires any new software be reviewed by legal, IT, and management prior to being implemented in a classroom setting.
So Ross, on that subject, can individual teachers sign up for free or freemium education services to use in their classrooms?
Many say nothing is free, and in many cases, from Facebook to your groceries frequent shoppers card, identifiable information or marketing information is your payment for the service. It's important to remember that FERPA has requirements, which we discussed earlier, that you must adhere with when using these types of software or apps. Also remember that many free apps can introduce security vulnerabilities into your school networks. Most importantly, we consider it a best practice to have regular trainings with staff around your policies regarding the use of software downloads at free services.
Good to know. Getting back to our list of best practices to consider, the FERPA does not expressly require that schools or districts use a written contract or legal agreement when disclosing information under the school official exception. We strongly recommend that schools and districts do so whenever possible. Not only do these agreements help with the direct control requirements we discussed earlier, but they also serve to clarify the use restrictions and other legal requirements that the provider is expected to meet.
Transparency is critical when it comes to communicating with parents and students on how data is being used, who it's being shared with, and for what purpose. We highly recommend that school districts inform parents of how children's data is being used, what information is being shared, and for what purpose in a public forum, such as a website.
And lastly, while there are many circumstances where obtaining parental consent is just not feasible, hence FERPA's exceptions, there are many other circumstances where obtaining parental consent is the best way to go. Going the consent route is a great way to increase transparency about your school or district's data use, and many districts are doing it to communicate with parents about what their kids are doing online. So we understand that it's not always an option, but we do recommend it whenever possible.
So Frank, what provisions should be in a school's or district's contract with the provider?
Another good question. Again, FERPA does not expressly require that schools or districts use a contract or written agreement with a third-party provider. But for all the reasons we've discussed, it is absolutely a best practice to do so. And there are a number of provisions that we recommend including in those agreements when you develop them. For starters, we recommend including data security and data stewardship provisions. Make it clear whether the data being collected belongs to the school or the provider, and describe each party's responsibility in the event of a data breach. You can even establish minimum security controls that the provider should use and allow for auditing of their compliance with those controls. We also recommend clearly specifying what information the provider will be collecting through their service, logs, cookies, tracking pixels, whatever it may be. It's hard to assess and mitigate the privacy risk of a technology if you don't even know what information it's collecting. Be sure to define the specific purposes for which the provider may use student information and legally bind them only to those approved uses. How long will the provider hold on to the data in identifiable form? Will they be permitted to share it with any other party? When the contract ends, how should they handle destroying the data? All of these are important terms to consider laying out in a written agreement. We recommend specifying whether the school, district, or parent will be permitted to access the data in the system, and if so, the process for obtaining access. This is particularly important if the provider will be creating or maintaining education records for the school, as FERPA's access rights would then come into play. We recommend establishing how long the agreement will be in force and what the terms are for modifying, amending, or terminating the agreement. This is particularly important for reasons we'll talk about a little later. And lastly, we recommend considering whether there should or should not be any provisions wherein the school or district identifies the provider or vice versa, particularly as it relates to the school or district's potential liabilities resulting from failure to comply with federal, state, or tribal law.
So what about online educational services that use click-wrap agreements instead of traditional contracts?
So as we mentioned before, click-wrap agreements are a particular form of legal agreement between the service provider and the user of that service. They are essentially a compilation of take-it-or-leave-it legal provisions established by the provider to which the user agrees by clicking Accept. Not accepting these provisions means not using the service, plain and simple. Well, these click-wrap agreements pose a challenge for the use of online educational services because they muddy the waters a bit about how the various legal requirements and best practices will be met. Consequently, we recommend that schools or districts take extra caution and apply extra scrutiny to these agreements before accepting them and using the services. First, schools and districts should be sure to check the amendment provisions. Many click-wrap agreements allow the provider to unilaterally change the terms of the agreement without notice to the user. Given the FERPA school officials' exception requirement to maintain direct control over the use of student information, we recommend that schools and districts exercise caution when agreeing to any of the terms of service that allows for amendment without notice. And if you do enter into them, we recommend reviewing the agreements regularly to determine if any provisions have changed. We recommend printing or saving any terms of service agreement that you accept. Remember, these are legally binding agreements between the vendor and the school or district. You should be sure you keep a copy for future reference. And lastly, because these click-wrap agreements are legally binding documents between the provider and the school or district, and because they are so easy to agree to with one click of a mouse, we recommend that districts or schools establish policies that specify who has the authority to accept the terms of service agreements and what they should be reviewing these agreements for prior to accepting them.
So I've seen in the chat box that this is the guidance document has been posted. Links to it has been sent out there, but here it is on a slide. So then also the resources on this page here are all sort of related to the topic that we're discussing, which is the model notification for directory information, our PTAC cloud computing best practices, a link to the Federal Trade Commission's resources on COPPA and children's privacy, and then the National Institute of Standards and Technology Cloud Computing Guidelines for Managing Security and Privacy. These links are all in the presentation, and I'm sure that they'll make them available after the webinar. So questions? I see the link just going through. Would a school or LEA having a strong policy on privacy and appropriate use of student information include requiring these in RFPs and contracts rather than relying on quick-wrap agreements? Is that a solution? Frank, I'm happy to jump in on this one. I mean, yes, that's certainly a good policy to put them in your RFPs and contracts. We recommend avoiding click-wrap agreements as much as possible. We do understand that sometimes it's hard considering the services that you need to use, but for anything big, getting it in the contract is a great way to go. And in fact, actually, it's one of the services that PTAC does offer. We will review contracts and MOUs in regards to privacy stipulation.
I agree completely with Ross. Sorry, I was struggling clicking off mute. Yes, certainly if you can get it into the RFP and the contract, that's a much stronger foundation than relying on the click-wrap agreement.
Well, if there aren't any other questions, we'll move along. Here's our contact information for the Privacy Technical Assistance Center. The important thing is the email address right there, privacyta@ed.gov. There's our website right there, and Frank, we have one of our favorite questions right here. And before I go read that, I will not. PTAC will not review click wrap agreements for you, but we will review agreements with MOUs and the like. But the other question is, can you share your thoughts about sharing info via email?
I was going to say, unfortunately, my microphone's not working, so I can't answer that question. But nonetheless, that is one of the things we're looking at currently. We have regular meetings. They're every week, and we're looking at a couple of the more relevant topics. Email. We know a lot of you are using maybe video in different formats, either to do remote observation, for supervising your teaching staff. So unfortunately, at this point, emails and the use of videos are some of those hot topics that we're currently looking at, and I'm not going to be able to give you a definitive answer today. My apologies.
Okay, go ahead.
This is Maria. I just wanted to jump in with a question that I have. So regarding the definition of educational purpose, sort of a two-part question. Have you defined that, or could you describe a standard for it? And then the second part would be thinking about states that have a diverse range of options around school choice. So whether that is charter schools, online courses, online schools, and wanting either the district or the state or the provider wanting to get the word out that those options exist. What do they need to be aware of to make sure they're providing outreach that meets the standard of educational use?
Well, certainly those types of environments with the charter schools and the high propensity for school choice, it makes it difficult. There are some provisions in FERPA around seeking to intend, but I'm not, without an exact use case, it's hard to say precisely if something would apply or not. You need to have good agreements in place with the organizations you're trying to share data with. So, for example, if it's a charter school that is newly chartered and it wants access to email addresses from the school district so it can go get the word out to all the members of the school district that, hey, this charter school is open and you guys can apply to it. That's where you definitely would want to go look at the school directory policy. And then of course, there's the question of whether or not the charter school is its own local education agency or whether the school is a part of the district. Really, a lot of words here, but it all kind of comes down to a fancy way of saying it depends. We handle questions like this on PTAC all the time. A lot of times with these types of questions, especially in regards to FERPA, there's not a single cut or dry answer on anything. So we do recommend, when we get those types of issues, there usually is a lot of deliberation that comes on during our weekly FERPA working group meetings. Then, Frank, did you want to add anything on that?
No, I was just going to say, and I being on the other end of the table for so many years, I know it's sometimes frustrating when you can't get definitive answers, but as Ross said, there's just so many different nuances. You have, each state has their own open records law provisions and different things. So really, to give those kind of answers, I would encourage you to use the email address, the privacyta@ed.gov. It comes in, and if it's an issue that we can address, we'll do that either informally or if you need something more official, we can do written responses. Of course, they take a little bit longer, but that's kind of what we can answer today.
Yeah, and I saw something, one of the clarifying question, at least, the quick discussion about how it corresponds with open records requests. That's actually a perfect example of the types of things that we deal with the FERPA working group. We actually are dealing with, I think, one or two of those cases right now where states are dealing with an open records request, but you still have to, even with those open records requests, you still have to keep FERPA in mind, and you have to keep in mind state legislation as well. So we're helping to work with that state to navigate through that open records request, because it's not an easy answer. And just because there's an open records law doesn't necessarily mean that you can have access to all the individual student records, including name and address and everything like that.
So just one last question before we bring in Themy. AJ Tyvan put in his comment that FERPA as a floor rather than a ceiling is a helpful thought for me. And I agree, that's a really helpful way to think about FERPA. And I just want to ask you, to the extent that you can comment on this, how we can talk about FERPA in the context of this much larger conversation that's going on in the state. You know, where do you see sort of the gaps that FERPA, which as you pointed out was written many years ago, is not addressing some of the concerns that states are now taking steps to address in either sort of prohibitive ways or ways to ensure better governance?
Well, I'll speak a little bit, then I'll go hand it right over to Frank. I mean, kind of, you know, FERPA being as old as it is, and we're living in a digital age now, certainly keeps us at PTAC gainfully employed and busy. As part of our regular FERPA working group, we do also discuss pending documents that we have that we're working on and dealing with other parts of the department and sometimes other agencies on various aspects of data sharing that FERPA might not directly address, or FERPA does address, but you know, there needs to be additional guidance on, much like the guidance, you know, with privacy, protecting privacy using online educational services. So there is an element of where the department is trying to release additional guidance documents to clarify some of the questions around the edges of FERPA. But Frank, I'll let you jump in and let you talk about the department's thoughts on FERPA as a whole.
Yeah, I think, as Ross said, we have several guidance documents kind of in the pipeline, some of which will be pertinent to the questions you guys are raising. But I think what some of the online services or some of the educational free services that are in use, it's really brought some of the provisions of the PPRA to the forefront. I think for years, even our survey said, you know, people didn't even really think of PPRA. FERPA was the federal law that came to mind first. And I think with some of the provisions in the PPRA regarding not using data collection for students for marketing, et cetera, has brought some of those, like the click wrap agreements to light, where you've had some large educational web-based services used by districts that they didn't really understand what they were agreeing to when they entered into those click wrap agreements. And as a result, there was, you know, data mining going on and some things like that. So I think that's some of like the most current things that we're looking at is how can we address that, making sure everybody's familiar or has an understanding of the PPRA in terms of how it's used today. I think certainly you've seen some things, Senator Markey's working on some different things. So I think that's kind of where FERPA ends and maybe some of the overlap with the PPRA, just getting that information out. So hey, maybe FERPA was written originally in the early 70s and didn't have that in mind. There are some other protections, PPRA for example, that come into play and really address some of these online services that we see in place now.
Okay then, well I think we are ready to hand the reins of the presentation over. Thanks for listening to us, and again, if you have questions, please feel free to email them to us.
Thank you so much.
Great, and Ross and Frank, if you wouldn't mind sticking around to the end of the webinar in case some more questions come up with Themy, but I'm going to bring Themy on right now. Themy Sparangis is the Chief Technology Director at LA Unified School District. And Themy, I'm really just curious for you to comment on, you know, some of your reactions to the presentation and talk a little bit about how LA Unified is using and protecting student data.
Yeah, thank you. And I know we're probably short on time, so I'll just spend a couple minutes just kind of reacting to the questions that you had. And I think if we go to the next slide, there we go. So, you know, obviously, I think the first bullet pretty much is self-explanatory, and our colleagues online probably already know that the more data we have, particularly down to the student level, the better information that we have in terms of to either personalize an instructional program to best meet the needs of individual students. And you know, we see this in our consumer lives, how you know, an out-of-the-box type of smartphone becomes personalized within minutes with background and music and all that stuff. Unlike the old days when you know, a regular cell phone would be the same for everybody except for maybe their contacts are slightly different. And so this is becoming commonplace in our personal lives, and obviously it affects our public lives, particularly our education settings. So everything from learning management systems, automated data, ways to give access to parents to provide intervention at home, intervention providers, both contracted and part of any school district, as well as just the teacher, him or herself, being able to understand where the gaps are and where the and to be able to direct the student to some learning resources that would be beneficial to increase student achievement and to help gain proficiency. In LAUSD, we handle student data, you know, very, very cautiously. We early on put together our Office of the General Counsel, together with our Data and Accountability Group, put together a series of policies that took all of the relevant aspects of FERPA, HIPAA, and then of course the CIPA, and you know, so everything from the Children in Protection Act, any new iterations of any of those laws, as well as any guidance, just like the guidance that we just heard from the U.S. Department of Ed, and tried to boil it down to a district policy as well as guidelines for ways to make sure we protect student data. And we approach it two ways. I mean, there's a legal obligation to protect student data, but we also see it as this is just a moral and an ethical obligation. This is a way to keep students safe. A big part of us as school teachers, as district administrators, as central office administrators, and all of the support staff, we just see this as a way to keep students safe. And the way we keep students safe is protecting their identity, making sure no harm comes to them, or at least doing as much due diligence to do that. So we see that as we see this more than just a legal obligation, and we try to teach that when we do our administrative certifications. And that's the way we share information to all of our faculty and staff throughout the district, whether they're in front of students or not in front of students. Twice a year we go through a certification process where everything from child abuse awareness procedures to student protection data, to protection of the student and employee data, to a whole bunch of policies and procedures to make our staff aware, as well as to give them the mechanism to be able to provide feedback so that we can better provide guidance. So we're very, very protective of student data. Sometimes our own teachers and those that want to access things online think we're too protective. We see it as it's better to be too protective, and then think about ways we can unlock access to sites online, as well as keep data protected within our network, versus being too open and then later playing catch up and leaving our students vulnerable. So the impact of the FERPA guidance is, it's really more the impact of FERPA, and obviously I made reference to that, as well as it impacts policy and procedures, and of course professional development. What are some of the things that we need to incorporate as we use a lot of these tools online, whether they're applications on computers and tablets that then connect online, or just the simple things of sharing information about students and what to do and what not to do over email, and how to connect best with parents and other people that do deserve and need access to information, as well as in protecting that information. And so the guidance that we get from FERPA is always helpful, and we're always connecting and our own listservs as we refine our own policies. What approaches do you hope policymakers will take in our state? I think this is really more of how do we take advantage of all of the great things and the proliferation of information that's online in such a way as to maintain protection, to help students understand how they can take ownership of protecting their own information, as well as employees and adults, so there's a learning experience there. And then also to be able to freely access information online, contribute to information online, and use a lot of these great tools that really are powerful learning experiences in virtual instruction and blended learning instruction, as well as own personal learning experiences. So I'll stop there because I know our time is short, but hopefully that kind of encapsulates the first part of the presentation and boils it down to a district perspective.
Themy, if I could ask you, how do you think about the definition of the term educational use? What are some examples you would give of thinking that through?
In terms of educational use of student data?
Correct.
Well, I mean, student data, and I don't know if I'm understanding the question correctly, so correct me if I'm wrong, but I mean, any type of use of student data from a district perspective would be for educational use. I can't imagine, and maybe I have too broad of a definition of educational use, but that's our bread and butter. That's our core competency is educational use. And so the only reason why we would use student data, whether it's testing data or other type of information for a student, is to better provide an educational or a learning environment that best meets the needs of each and every student, so that they can, be career ready and college ready and to be able to gain mastery across all of the different content areas that we want to provide them. Great.
That's a really helpful answer. And just one final question, because we're running out of time. Themy, do you have a link that you can share to LAUSD's policies around student privacy?
I'd have to find it. We've got from our, what I can do is share with you, and we've got several policies that are publicly accessible. A lot of our information is really more policy bulletins that obviously can be freely shared but may not be freely accessible because they're usually somewhere on our portal. But I'd be happy to share that with anybody that's interested in our either information protection policy that our Office of the General Counsel created, or the or IT security policy, which helps protect the information based on the information protection policy.
Great. So if anyone wants to follow up with me, my email is on the bottom of the slide. If you'd like to reach out to me for any information or links that we shared during this webinar that you'd like to follow up on, I'm happy to do that. So with that, Themy, I would like to say thank you so much for lending your local perspective to this conversation, and to Frank and Ross. Your description of the guidance was incredibly thorough and helpful to the field, and we just want to, again, thank you, as well as the Secretary, for your leadership on this very important issue. This webinar will be archived, and the link will be available in our member forums. So I hope everyone has a great day.